Welcome to Gloves Off, hosted by award-winning trial and personal injury attorney Ven Johnson, founder of Ven Johnson Law. In each episode, Ven goes toe-to-toe with guests, hashing out legal matters around the most talked-about news stories and issues. We don't pull any punches, so some language and topics may not be suitable for younger listeners.
Morning, afternoon, good evening, good day, everybody. Ven Johnson here with Gloves Off podcast number 30. We made it to 30.
That's amazing.
It only took 14 and a half years, but we got to 30.
That jumped up a notch. It did, didn't it?
Shout out to my daughter, Ari Guajardo Johnson, who kept telling me, Dad, you need to do more podcasts. Well, guess what? It took me a year and a half to do one. But in the unlikely event that y'all have not listened to and watched episode 29, when I had my distinguished guest, Jason Carr and Chris Desmond, also Steve Fishman, please make sure you do that. That is a long one. But boy, did we get into some deep stuff about what's kind of going on federally right now in the area of civil rights or lack thereof. And as in particular, the impact that that's having on the Patrick Lyoya police shooting case. But today I want to start with guys. Jason Carr, thank you again. Chris Desmond, thank you again. Let's talk real quick about Oxford. Chris, you've been handling that appeal for 400 years now. What's up with the Oxford High School shooting tragedy civil cases?
So the most recent news that broke this week, then, is that the Michigan Supreme Court, after we took our fight regarding Michigan governmental immunity to the Michigan Court of Appeals and didn't prevail at the Michigan Court of Appeals, we filed what's called an application for leave to appeal to the Michigan Supreme Court. That's just saying to the Michigan Supreme Court, will you hear this case? And this week, we received an order from the Michigan Supreme Court denying that application and saying we are not persuaded that we should address this issue at this time.
Yep. So that's within their prerogative to do that.
That's totally within their discretion. You have a right to appeal to the Michigan Court of Appeals. The Michigan Supreme Court is a court of discretion. They decide which cases they want to take, which ones they don't want to take. They take roughly 30 to 40 a year. There's not a lot of cases that go through. The Court of Appeals will do 100 in a month sometimes. They do about 30 in a year, and so they're very selective about what they take, and they decided not to take the Oxford case, unfortunately.
So as it relates to our state law claims, in other words, Michigan law, what's left?
We have a constitutional claim. This is a claim under the Michigan Constitution. It's kind of a novel theory that is pending in Oakland Circuit Court right now. There's a motion to dismiss that's already been filed by the district on that claim, and we're awaiting our day to argue that claim. But yeah, this was a significant portion of the case that was at issue in the Michigan Supreme Court application.
Should we reset the table of what we're talking about here?
Do it.
Ven Johnson Law represents who in the Oxford shooting case of November 30th, 2021?
Multiple families, but the ones that most notable and recognizable to the public would be Buck and Sherry Meir, M-Y-R-E. They're the parents of Tate Meir. And we represent Justin Schilling's family, Craig Schilling and his mom, and Justin's mom, Jill Suave, and their family for Justin's death. We also represent the Gregory family. Keegan Gregory was in the bathroom where Justin Schilling was murdered, and a number of other students who were in the school, right, Chris?
Yeah, a number of other students, 3 other students who were bystanders that were in the school who obviously were terrified along with all the other students.
Okay, so you have criminal convictions of the shooter at Oxford High School, Ethan Crumbly, and his parents, Jennifer and James Crumbly.
And just so you know, we get yelled at if we use the shooter's name.
Yeah, we just call him the shooter.
So we call him the shooter.
Okay, and
by the request of our clients. And so I'm not being a smartass. That's what they've asked us to do, and that's what we're doing.
Okay, so
Thank you.
We could even delete that in post.
No, leave it. It's fine.
That said, you're representing the families, okay? There were circumstances that perhaps or likely contributed to this shooting happening in the first place. Your contention, Ven Johnson Law, your contention is?
Oh, simply put, there were 400 things that should have alerted the school and the school personnel, and we had named the people and what they did and didn't do, that the shooter was going to do something very bad. They knew about it and did nothing, up to and including ignored at least 2 different hand-drawn pictures of someone shooting somebody else within the first 2 months of school from early September through November 30.
Including the day of the shooting.
And then another one on the day of. He's watching videos of ammunition that, by the way, fit the gun that he had in his backpack. He was watching violent videos of some movie where people were being slaughtered, okay? And all of this was known and given to the counseling office, where ultimately they met with him and thought that he might be considering suicide. So they did their intervention with him in the office, mom and dad in the office, his mom and dad, telling them, we want you to take him and get him evaluated. They said, we can't. We have work today. They left. School didn't send him in with a cop, have him come in, didn't have him evaluated, didn't send him to an emergency room for an evaluation.
Keep him in the counselor's office for the remainder of the day, as they had previously done with other students.
Went down to the classroom where they took him out of, where his backpack was, took the backpack, realized it was especially heavy, gave him the backpack without looking inside the backpack, never searched his locker like they would for pot, for cigarettes, vaping. And then the shooting happened about not even an hour later.
Well, with all of that being said, Chris, why did the Supreme Court say that?
It's what we talked about in episode 29 in a lot of ways, governmental immunity in a different context. This is state governmental immunity instead of what we call qualified immunity at the federal level. But you know, we've said this over and over and over. If this happens in a private school, which we obviously would never hope for or want, but if this happens in private school, there's not a question that the school is liable and has some share of liability in this. But when you sue the government in Michigan under Michigan law, instead of showing that they were a cause of what happened, you have to show that they were the cause of what happened. That's courtesy of a Michigan Supreme Court opinion from 2000 called Robinson versus City of Detroit that
the bane of our existence.
Changed the law in Michigan. This was not the case before. Before, you used to be able to show a cause. They changed that in 2000, and ever since, families like these families have suffered as a result.
Let me geek out for 1 second, Jay, because you semi-like it, and then you're going to break it down. I know you are. In every other type of case, in criminal law and civil law, except for governmental immunity, the standard is a proximate cause. You have to be in this, and the jury gets to be instructed, and it's read to them.
And there can be several causes.
There can be several. It doesn't have to be the one and only, doesn't have to be the last. It's for you to decide whether there was a sufficient enough of a connection between what the person with the burden of proof, us, says that they did wrong, and then the injury or death. Okay, so here what we're saying is they played a role. The teachers and the administrators and the school district played a role. In the criminal case against the parents of the shooter, guess what they were instructed on? We call this proximate, Proximate, proximate cause. That means relationship between some misbehavior and the outcome. Guess what the standard was given to the jury on what they had to prove, the prosecutor had to prove to convict the parents? A proximate cause. So the parents of the shooter have been convicted and are in prison because of a proximate cause. But when I want to sue a city or the government, Oxford Community Schools or one of its employees,
On behalf of the family,
I have to prove it's the. So what the trial judge did is she said, since the shooter was the shooter, that is the proximate cause. It can't be anything else. So there's no reason for you to go to trial, Johnson. And
So in a way, I mean, it's easier to take away a private individual's freedom in Michigan than it is to take away the government's money. I mean, it's kind of a way to look at it.
And that's traceable back to 2000.
To a decision in 2000.
And the statute, that was before, but the statute was interpreted differently before. But yes, it's crazy. Okay, and here's the kicker. When you have a really big case, and if you were to look at, for example, the criminal cases, we talked last time about the criminal case in Loyola, and we're going to talk a little bit later today, I think, about the criminal aspects of this case called Samuel Sterling. When you see what happens in the criminal case and the appeals, you will get, usually, like there was in Loyola, multiple appeals by the defense team for the cop saying this case should never go to trial, it should be thrown out.
Okay.
So there was an appeal from the district court's ruling in the bindover. That went to the circuit court. Then there was appeal of that. It went to the Court of Appeals. Then there was appeal of that to the Supreme Court. All of these courts actually heard the case, including the Supreme Court, I believe. Am I wrong on that?
I think they denied the app at the Supreme Court. I think they just denied the app.
Okay.
But yes.
But wasn't there a second round, Chris, of
There
appeals?
was a second round. I don't remember if there was oral argument in the Supreme Court, but yeah, he has had many, many rounds through every level you can.
And so here, in what we believe to be the largest and one of the most significant civil cases in Michigan jurisprudence system, the Supreme Court that could have heard the case, we didn't ask them at this point to rule our way. Would you just please hear the case? They told us no. And they told us no, slam dunk. It was 6-0. There's 7 justices. One just got appointed and just got on the bench. So he did not, Justice Hood did not take part. But the other 6 all voted no.
Is that politically persuaded or motivated?
I don't think so. I'd say it's the exact opposite.
You don't think that the Supreme Court in Michigan leans a certain way in terms of conservatism and being in favor of government immunity?
Let me explain why. The answer is
I ask as a layperson.
As a layperson,
I'm trying to understand.
The Michigan Supreme Court is a 7-justice panel. 6 of those people are Democrats currently for the first time in Michigan history. 1 is a highly conservative Republican. So politics, here's what you need to understand about politics in the law, at least here in Michigan. Democrats believe in letting cases go to the jury and let the jury decide. Republicans, they will tell you they do. Republicans are more into having a judge rule and throw cases out of court without ever going to trial. Okay? That is how it has been in Michigan, Chris, in Michigan appellate law since easily the 90s.
Yeah.
Through about now. Agreed?
Agreed, yeah.
Okay. So
As
I'm
an
not
average
just making
person,
this shit
that
up.
does not shock
The
me.
general trend, that's trend, yeah.
Right. So, and again, just because Democrats are on, I don't win. I just get to go to trial and let the jury decide. Whereas the Republicans would rather the cases be thrown out. And so 6-1, you would argue, wait a minute. If we believe in the jury system, then why not do it? And I will tell you this. Normally, I would say, yeah, I think we got a really good shot. But governmental immunity, guess who enjoys governmental immunity too?
Who?
The Michigan Supreme Court. And the governor and the attorney general and every single person that works for the government. And that's not just the state of Michigan. That's also counties, municipalities, cities, townships, villages.
So what you just said, in effect, is the Supreme Court is like, hey, normally, under every other circumstance, because we're 6 Democrats and 1 conservative, that we would allow this to go. But because
we would simply hear the case is what you would expect.
Right. But because we're not immune, or now we count on government immunity, so we'd kind of be opening the door for ourselves to be.
Let me be really clear, because
challenged.
this is a great question. It's a cross-examination question. I am not saying that's what happened. Do I believe that is a factor? And the answer is yes. I believe that it is not lost on a Supreme Court justice that if I open the door to revisiting governmental immunity, some lunatic out there could sue me for something. And so I believe it is something that folks would consider. Now, Chris, you may feel differently.
Well, yeah, I do. One of the other things that I think people need to, and this is where it gets real nerdy from a legal standpoint, is a Latin phrase called stare decisis. Stare decisis basically says when you have a decision, when something has been the law of this state for a long time, we don't want to disrupt things. We believe in continuity. We believe in consistency so people understand what the law is. And a lot of times you'll hear the Supreme Court invoke that. Now, something people need to know. In the early 2000s with the Engler justices, and people referred to them as the Gang of Four, what that court was often called.
Because they had 4 Republicans, 3 Democrats, and guess what every decision boiled down to of any major import, especially in personal injury.
Basically along party lines.
And they came in and they disrupted Michigan law in ways that no Michigan Supreme Court ever had. They threw out precedent after precedent after precedent, including the very one we're talking about here that used to say a proximate cause is good enough against the government. They changed that rule. Since then, it's kind of locked into place. And it's, well, now we don't change the law anymore. We did back then, but we're not going to do it anymore. And so we're still saddled with a lot of those decisions that I think were injustices, that I think improperly changed Michigan law from what it was. And so this Michigan Supreme Court very well may have just been saying, we believe in stare decisis and we're not going to change the law. One of the things that I'll say I'm frustrated by with this decision is that the Supreme Court, they don't have to tell you why they ruled a certain way, because they don't have to take a case. They can just say in a one sentence thing, we're not taking this case. And I get that that happens a lot of times. In a case like this, it's a devastating case, and it's beyond a devastating case. I mean, if you've spent time with these families and if you've sat through the evidence the way that we have, it's horrific. It's horrific. And for them to not have some understanding that if that's the reason why it's stare decisis, for them to not know that, all they know right now is the court won't hear us. And that can be very frustrating. I would imagine as a layperson, it doesn't always make sense. Like that the highest court in the state can just say, we're not telling you why.
And again, I want to point out, Jane, forgive me for interrupting. At this point, we were not arguing to the Michigan Supreme Court, you need to reverse anything.
No, just hear it.
Just hear it.
Interesting, because once upon a time, when I was still working in television news, the national folks came to town. One of those back and forth yell fests on cable news where you've got your person on the left, your person on the right, and the host. And they came to town and they did a show on location at Greenfield Village Henry Ford Museum. So I went. I was there with Fox 2. I went to cover this. Hey, the show is in town kind of thing. And I watched as these guys argued and yelled back and forth the panel at each other for 22 minutes plus commercials. And then when it was all said and done, they all stood up all backslapping and congratulating each other on a great show and asked where they're all going to dinner together. So this idea that, like, no matter if you're right, left, Republican, Democrat, but at the end of the day, we have to protect government immunity is a fascinating kind of peek behind the pay no attention behind the man, the man behind the green curtain sort of thing.
So on your point, I think it would have been incredibly wise for the Supreme Court. And one of the things that I know Chris and I agree on, but Chris, you guys, I know I've told you this before, the top appellate lawyer, not just in our state, but one of the best in the country, and knows more about these issues than anybody. And what I can assure you is that there is no decision by the Michigan Supreme Court that actually analyzed governmental immunity on gross negligence and the proximate cause in general, that went through all the elements and said, you know what, now that we went back through and read what the legislature was trying to do and the ills that they were trying to prevent and all that shit that you would do when you're doing what we call statutory lawmaking reviews, but not a single Michigan Supreme Court decision ever did that. They just always assumed it was constitutional, which makes no sense. So the Supreme Court could have said, we want to hear the case, and they may have ruled against us ultimately and said, you know what, governmental immunity is a lawful thing, and go from there. So it doesn't guarantee us a win. So to me, it makes it even easier. Grant frickin' leave, take the case, and figure out what it is that you 6-7 justices believe to be the law.
I don't think we've ever even really figured out why governmental immunity exists in this country, frankly. If you look back at it, governmental immunity predates the state of Michigan. It predates the colonies. It's something that goes back to Europe. It's the concept that the king can do no wrong.
Right.
You can't sue the king. And so when they came over here and they started to set up forms of government and legal systems here, that was one of the rules they maintained, while at the same time talking about how we don't believe in kings. So we don't believe in kings, but we're still going to give them these special protections that other people don't get. And I don't think we've ever really wrestled with the philosophical underpinnings of why is that the case.
So,
well, at the end of the day, the argument could be made that you have to protect the interest of the rich old white establishment.
There we go. Finally, we're getting there. Yep.
Back, into the annals of history.
So here's what's an interesting Michigan twist, and one of the reasons why, in addition to abolishing capital punishment in the mid 1800s. We were one, in fact, I think we were the first state, I believe, that outlawed capital punishment in Michigan. I don't know if you knew that. I'm proud of that, okay? And I'm not pro-prisoner, right? But if we don't have to kill people, then let them rot in jail. That's not true. Treat them like they have rights, but put them in jail and let them be there. But anyway, Michigan in 1961, the year of my birth, ruled in a 5-4, because it used to be 9 justices, in a 5-4 opinion, ruled against governmental immunity. And it was Justice Black. Chris and I have read this case, and it's the coolest thing, because he goes through and goes, why are we even talking about governmental immunity? Back in the day, it made sense before insurance, when cities were not made up of that many people, there weren't that many tax dollars, we were more disjointed. But now municipalities are like corporations. So he then said that we don't protect corporations. We don't give corporations immunity. Well, we do now in Michigan, but I don't want to talk. Back then we didn't. So he said, and the ruling of the Michigan Supreme Court was, bye-bye governmental immunity. It didn't exist. 2 years later, I think it was
1963.
Then the statute came in. The legislatures got all pissed off about this and the floodgates of litigation. We call it floodgates of litigation. Everyone's going to sue everyone for no reason. Guess what? It is a horrible argument. Every law school professor that teaches these calculations, it's a horrible argument. It never happens. Guess why? Because it doesn't. So then the legislature changed the law and added, was it gross negligence then, Chris?
No, that doesn't come until 1984. But they, in 61, when the court's saying we rule against governmental immunity, it's basically saying without the legislature saying there's governmental immunity, it doesn't naturally exist. And so we don't have a law in the books saying it's there, so we're not going to allow it. So 63, the government comes in and says, well, now there is a law on the books. But
nothing really happened. And you could basically sue the government for pretty much anything. From 63 to 80, was it 86, 87?
84, the Governmental Tort Liability Act.
And that's when gross negligence and the proximate cause came into effect. But when it came into effect, no one paid attention to it and thought it really meant anything. I become a lawyer 3 years later, 2 years later, 86. I start doing this area of law, and I was a defense lawyer. So I was a lawyer for a defendant. And it was a horrible case. School bus ran over a little boy, okay? I'm representing this bus driver who clearly didn't see the kid and ran over him, and the school district both. I'm talking to my boss, John Secrets, and I'm like, wait a minute, what's this gross negligence and the proximate cause shit? I've never even heard of that. Secrets looks at me and goes, I've never heard of that. We never even filed a motion, Chris. We never tried to get out. So I'm just telling you, in those days, no one frickin' paid attention to it. And then later on in the late 90s and early 2000s, when Engler got involved and then started appointing, Engler appointed more people to the bench than any other governor.
I know. Would you say that in terms of modern political history, or even just history period, that Engler had more of an impact on the state of Michigan than perhaps any other politician in the 20th, 21st century?
Absolutely. Indisputable. Agreed?
From a judicial standpoint,
and from
for
this,
sure.
Today, we're still undoing the shit that they came up with. And what's really funny about it, Jason, on that, Engler was a licensed attorney. I don't think he ever practiced law. His wife was a licensed attorney who did medical malpractice, birth trauma cases like me, only she was from Texas. So he had 2 lawyers who came in and destroyed this civil jurisprudence system on purpose as a matter of tort reform, because of course we were ruining America. And guess who his pal in that was? Some guy named Bush, who was the governor of Texas, who was the leader of the Governors Association. The chair was Engler, and the person running with actually the strings from behind, some guy named Carl Rove. Mm-hmm. I bet you didn't fucking know that.
Oh, it doesn't surprise me. I wouldn't say that I would have won a trivia contest on it, but I would have been a guess. It would have been a guess.
So hear me out. So my point is on all of this is, okay, at least acknowledge that there's an issue. We need to clarify this stuff. And this is one of the biggest, most horrible things we've ever had happen in Michigan. Let's give these people their day in court.
If this was still 1961 and you were representing the families, how different would it be for the families in Ven Johnson law?
They would have paid, first of all, they had only $6 million of insurance, which is offensive. They would have paid that policy, which is what they should have done in this case. They would have paid that the next day. And a lot of people say, Ven, then are you really doing this only for $6 million? The answer is no. I didn't do this at all. In fact, I knew from day one that my clients, right, were going to never be fully compensated.
And our clients, or only some of the clients, that
Right.
$6 million is divided up among every single victim in that school that
There
day.
were 55 bullets or more, depending on who you believe, right, that were shot that day. Okay. There were 4 deaths,
12 people shot total.
Okay.
So that $6 million
it's
doesn't
nothing.
go
But
long at all.
Right.
But at least if that's done at the beginning of the case and they come forward and just say, you guys, we'll figure out a way that you guys share the money between the families, which happens a lot in major tragedy cases, then at least they're stepping forward and doing what they can do. No one's going to go in and say, yeah, screw them. We want to shut down the school and we want to bleed every tax dollar. My clients loved Oxford. They would never have done that, but they didn't do that here. And by the way, even toward the end, they barely did anything, but I'm not going to talk about that. But in any event, so that's what happened on Oxford, y'all. And all I can tell you is stay tuned because we're not done. And Chris and I were looking at emails today. What I'm just going to tell
you're
you
not
is
done. This episode's done, but you're not done.
Exactly. But what I'm going to tell you is this. There is going to be a public march. And I'm hoping it's in June. Could be July. Stay tuned.
And again, let me restate that as we tape this podcast today, it is May 30th today. And
Correct.
so when you're talking about June, you're just talking within matter of a few weeks.
Correct. And what we want to do is we want to invite every Michigan resident that was moved in any way by this Oxford tragedy, the failure of our state government to come in and do an investigation from the beginning, the failure of the school district, the multiple folks from the school district that made mistakes and yet never will be held accountable, even though their own internal investigation guidepost calls out their behavior and says, without any question, they played a role in the shooting. Chris, you've read it. It was sitting on that.
It's horrific. It's over 500 pages of evidence detailing exactly what happened that day and what didn't happen that day and what could have happened that day to stop this.
And so all of that will never, ever apparently be anything. And so what we want to do, we want to march in Lansing. We want to talk about how the evils of governmental immunity. We want to talk about fairness under the law. We want to talk about this legislature voting into law fairness again as it relates to, if you're going to have governmental immunity, how about having just the standard of every other case?
Yeah.
That it's going to be like every other case and treated different, not differently where anyone's above the law. So we're going to do that. We're going to announce that. And I'm hoping we have a lot of people in Lansing that day.
I mean, we haven't done a single thing to change anything in Michigan since the day of that shooting. Nothing. There's not anything different in place, not a policy, not a rule, not anything that would stop what happened in November of 2022 from happening again. Or
Well,
2021.
and that's not just here. That's in so many
That
cases
is-
where once the thoughts and prayers have
Right.
been
Once it's
invoked,
not in the news anymore, it's not on people's
and
minds.
the TV cameras are gone.
That's right.
All right, let's do this because we're circling the time here. I just want to talk real quick about a case that's called Samuel Sterling, y'all. This is another police, what you call it a police misconduct case. It's an excessive force case. And maybe we need to come back and get Fish's interpretation of this, but he's going to check it out because he doesn't want to call anything out. We just got news 2 days ago that the case against the Michigan State Police trooper, and let me remind everybody, the gentleman was a Michigan State Police trooper that ran over a young man that was running, and he crushed him when he went up and over the sidewalk, crushed him against the side of a building of a Burger King in Grand Rapids. And Samuel Sterling, this guy Keeley, was
Michigan State
prosecuted.
Police Detective Brian Keeley.
And who, by the way, was suspended as a trooper that day by Michigan State Police, to their credit, because they saw the videotape. They suspended him without pay, which they almost never do. That tells you they know what was wrong. That led about 30 days later to the Michigan Attorney General's office charging their co-employee, State Trooper Keeley, with second-degree murder. to their credit, because it was wrong what he did. He used the car as a deadly weapon when the situation did not call for deadly weapons. This Sterling was being chased. They were calling him by his name. Samuel, Sterling, stop. What are you doing? You're surrounded. They had like 15 guys all around him. He wasn't going to get away. Okay? So what are they doing other than killing him? So what happens is, in state court last year, they did the normal, it's called a bind over. They did a preliminary examination. He's now in circuit court in Kent County. And the criminal defense attorneys for Keeley. Oh, by the way, Keeley then was, when he left the Michigan State Police, they negotiated a deal, and he retired with full benefits. Just like Schuer did, by the way. When Schuer was the guy from Loyola, when he was charged, they allowed him to retire with full benefits. And
off the top of your head, how old is Keeley?
Keeley is probably in his 30s.
No, Keeley's I believe in his 50s.
Really?
Yeah, Keeley had been a trooper for a significant period of time.
But not typical retirement age.
No.
So,
and you don't, by the way, if a cop is being charged, the last thing you do is allow him to, like at Johnson Law, if you did something that I'm firing you for, I don't give you full retirement benefits. You get whatever you accrued through that day, and you get out of there. Huh? He's 50.
All right,
okay,
so our
thank you,
producer
Chelsea.
says he's 50. Thank you, Chelsea. My point being is that he runs down and kills
and crushes. Yes.
Mr. Sterling.
Yes.
I hesitate to use the word reward, but the outcome of that incident for him is an early retirement, fully funded.
Yes, by the taxpayers.
By the taxpayers. And now he can, at age 50, go get another job at another department, police agency, if he so chooses, earn a full income there, and then retire from that department too.
Yes.
Is that not correct?
Yes. You have a problem with that? Why? I know. Honestly, Jay, you can't make this shit up. But hear me out. So now we're in state court in the criminal case. In a normal case, just like the case against Schuer in Kent County. And by the way, do you think there's a coincidence that every case that we would be talking about today is 3 dead people, 1 severely injured guy? So on the 4 cases, all occurred in the city of Grand Rapids or the surrounding Grand Rapids community. But there's not a problem on the west side of the state, right? In any event. So the criminal trial is now going forward in its process. And the defense team for the cop, Keeley, filed this thing called a removal notice. Explain, Chris.
So Trooper Keeley that day was operating as part of a joint task force with the federal government. So he's a Michigan.
Oh, no. You just used the word federal.
So he's an employee of the state of Michigan. There's no question about that. There's no debate about that. He had been for a long time. But he's cooperating with the feds as part of this task force, a fugitive apprehension task force.
Chris, who pays him?
The state of Michigan pays him.
And the car that he was in, who pays for that?
Our belief is the state of Michigan owns that vehicle.
But
he's
a federal task force.
Cooperating with the feds. And so as a result, they remove it to federal court and they say, well, he's a federal agent. And there's something in the Constitution called the Supremacy Clause.
So what does removal mean?
Removal means it's no longer in front of a state court judge like the Christopher Schuer trial was. It's now going to federal court, and it's now in the Western District of Michigan in front of a federal district court judge.
Judge Darbo in Lansing.
And so then Mr. Keeley filed a motion that says under this thing called the Supremacy Clause.
Which is what?
It's a portion of the Constitution that it's basically a notion that federal law is supreme to state law in certain instances. And so he argued that under the Federal Supremacy Clause, because I was working as a federal agent that day, as long as I was doing my job, I can't be criminally prosecuted in this court. And
governmental immunity only in civil criminal cases, Jason.
So with Officer Schuer, even though we obviously vehemently disagree with the result of that case, and we at least had a trial in that case. There was a criminal trial where a jury had an opportunity. We're not getting that with Keeley by virtue of this Supremacy Clause. So simply because he was on this federal task force and the feds aren't paying him, the feds aren't employing him, he's no longer going to stand trial.
So hear me out. So they filed this notice removal thing, and then there's ultimately some kind of a hearing where the state attorney general's office opposes it and says, Judge, we shouldn't be here. This is a Michigan situation. Judge Jarbo rules, no, this is proper in federal court because of him being on the federal task force. And so I go to my best friend in the entire world, other than you two. Sorry, Mark Riley, and you, and go to Fish. Fish has been a lawyer for 197 years. He's never even heard of this, ever. And I go, wait a minute, how have you not heard of this? So I sent him the opinion. And he goes, I have never heard. And by the way, Fish's practice, he said today earlier, a different episode, he said, I don't practice in state court. He practices only in federal court now because that's where he wants to. And it's a federal court matter, and he's never heard of that. And he's a criminal defense attorney.
There's a lot going on in the world today that hasn't happened before.
Okay, so now Judge Jarbo has an evidentiary hearing, where she heard evidence by the prosecutor and by the defense on basically what happened and why it's either okay or not okay. Chris attended that. Ayana Hatch attended that. And so we know what the testimony was and wasn't. So then, she then now, after hearing that evidence, rules. And by the way, I asked Fish, when's the last time there was an evidentiary hearing on whether a case...
Like a mini trial?
Yes.
Couldn't she have just said yes or no?
With experts.
Couldn't she have just said yes or no?
And again, I'm telling you, Fish has never heard this ever before, nor has any other criminal lawyer, defense attorney that I have talked with about this, by the way. And so now we're there. She ruled, Judge Jarbo, which is her discretion, she ruled that based on that evidentiary hearing, that she has no say, can't go to trial, and throws out the criminal charges. So now what you have is, you have Dana Nessel, and did you see any of General Nessel's comments about this case in the last couple of days? I implore all of you, I don't care what anyone says, good or bad about Dana Nessel, listen to the words she uses.
The Attorney General.
Yes, of the state of Michigan on this ruling. Never heard of such a thing, never seen such a thing. This is I think she called it a travesty of justice. So now the state attorney general of Michigan is now in the process of determining whether she wants to appeal to the United States Sixth Circuit Court of Appeals, saying, wait a minute, you can't just take away our prosecution. So again, I say to the criminal defense attorneys out there, call me, send me an email if you've ever heard of this, because it's never happened before, at least to us in what we've seen. I know there's another opinion out there from another case.
From other states. I mean, there are cases from other states that have come up that
criminal case against Keeley is now gone. So now we have our civil case. We have two aspects of our civil case. We have our excessive force civil case that we bring under federal law. Guess what judge we have? Judge Jarbo.
Well, now how is that?
Because we do. And then in the other part of our case...
I mean, layperson, that doesn't seem fair.
Well, it happens all the time, but that's fine. There's only so many judges from over there to assign, and I'm guessing someone thought she knows the facts, and so that's fine. I've known Judge Jarbo for years. I have great relationship with her. Doesn't mean she's going to rule in my favor or not, but so we'll go and we'll do what we do. So the other part of the case we had to file in state court because we filed state of Michigan claims in the Court of Claims. Chris, Jesus, try to explain that in 2 seconds.
So we talked about governmental immunity. There's a big statute called the Governmental Tort Liability Act that says you can't sue the government unless it's one of these 5-6 situations. One of them is called the motor vehicle exception. And that says if a governmental employee is using a government-owned motor vehicle negligently and causes someone injury, you can hold them liable. So we sued the state of Michigan saying, okay, Keeley saying I didn't intentionally run him over. It was a mistake, meaning it's negligence. So we sue under the motor vehicle exception. Now they're arguing, well, we don't really own that vehicle. That's the Fed's vehicle. So even though it's being driven by a state...
Can't you just subpoena where's it registered and who's the title holder?
We're trying to, but they won't respond because they have their motion pending. Welcome to our... And by the way, if we win that motion, they then have an automatic right of appeal to go up to the Michigan Court of Appeals. And that'll delay this case. We won't get able to subpoena. We won't get any depositions for another year and a half.
Okay, time out. I have a question. Only one?
You all think I just make this shit up.
Okay. And by the way, this podcast is not scripted, by the way.
Really?
Okay, so at what
What's
point?
Josh doing then?
Sure, they can tell that. But
At
Holly's
what
over there
point-
playing the wiki board. I know what she's doing. Chelsea's telling us the real facts. What is Josh doing?
Well, we got Holly over here on the wheels of steel on the ones and twos at the control board. Here's the question: at what point does this stop being about Officer Keeley pulling a Death Race 2000 and jumping a curb and running down a pedestrian, and when does it become, behind closed doors? Look, guys, we got to circle the wagons here because this is really about protecting government immunity going forward and not protecting just this one officer. At what point did this turn the corner?
He sits back in his chair to defer to. The answer is it's all involved in every one of these fucking cases.
If it was just about Officer Keeley, would it be Fed, state, all these different, directions that.
Well, since Officer Keeley works for the government, then the answer is you could argue it's not just about him. But yeah, if you're saying if he worked for Ven Johnson Law, let's just say that, and he unfortunately ran over a pedestrian and crushed him against the Burger King wall, Ven Johnson Law would send a letter to its insurance carrier, have you lost your fucking mind? Pay the money now. Chris?
yeah, no, that's right. I mean, it's only because he's a governmental employee. This case is entirely.
It becomes
it is the easiest case in Johnson Law if he doesn't work for the government.
Right.
The easiest case in Johnson Law.
It becomes bigger than the officer, bigger than the victim.
It's protecting the system.
That's what I'm getting at.
Yes.
This
Yes,
is
but that's what they've done for the last, and this is why it's so important that our Michigan Supreme Court take one of these cases and look at this, because they are abusing what was the law. They are now taking it and absolutely they are, it's abuse of power is what it is. And that's why it puts the state, not just the state, any governmental entity, it puts them above us under the law. If I said, let's go to the most grotesque example of racial discrimination you can think of. And sadly, our country knows that. And for years, not only did folks of color not have the ability to vote, but wouldn't be able to sit on a jury, and couldn't do anything, right? So if I made a rule about you can't do this if you're black, you'd say, are you fucking kidding me, Ven? That's discrimination. Okay, so what do you call it when it's not about the color, but it's who they work for? How does that give them more rights than me? I pay their salary.
you can't sue the king.
And to flip it,
point.
how does
And when
it
the
give you less rights as a victim because of who you were injured by, right? You have two people. If we have a pedestrian, and we have these cases, we have a pedestrian who gets run over by a trucker who works for a trucking company. We don't have to tell them the things we have to tell Samuel Sterling's family. Only by virtue of who he was victimized by is he facing the struggles that he's facing.
Right.
So I hate to date myself here, but there was a movie once upon a time called Network where Peter Finch, as the anchor Howard Beale, saying, I'm as mad as hell, I'm not going to take it anymore. That's all fine and great when the ratings are going crazy and everybody's making money, but ultimately he goes too far and he gets called into the boardroom. Right. And Ned Beatty is like, you are messing with primal forces. You have no idea.
Thanks for the spoilers, Jason.
I feel like government immunity is kind of like Ned Beatty in that boardroom dressing down Peter Finch, Howard Beale, saying, look, no, you can't sue the king. You can't sue the king.
Here's what I say. When I explain this to my clients, which I do obviously in every case, I say governmental immunity is you can't sue the king, but if you do, and we say you can't sue the king unless the king says you can. I should say king or queen. But when they say that you can, they really don't mean it. So these exceptions that Chris has talked about, if I were to go through, and we're wrapping up, so I won't, but if I were to go through some of these examples of what the exceptions are and how they've been interpreted under the law, there's this thing, for example, called the public building exception to governmental immunity. Chris and I have had these cases. So when our young lady leans backwards against a window in Case Hall that and then falls 6 stories and crashes to the ground and somehow lives, okay? That's government, but the building, it was 12:15 in the morning. So even though they took her ID on the way in and checked it,
she's allowed to be there.
She's allowed to be there. She's lawfully there. It was after the building closed, so it's no longer a public building.
Had she fallen out that window?
Did you hear me?
Had that window
it's not
failed
a
a half
fucking
hour
public
earlier?
building. Did a different building come fucking fly in, Jason, and become a... Okay, I'm not done. How about a little kid who's in elementary school that gets crushed by these picnic table things that were just leaning up against the wall that they use for cafeteria?
Mm-hmm.
That's not a part of the building. Excuse me? My kid was alive. They were in kindergarten and they were getting ready to go eat and gets crushed by this thing that you didn't secure. It's not a part of the building. That's not a public building exception. Jason, we have examples of example, and that's just that, dude. It is so grotesque on what our courts, and it was primarily the Engler courts, have done. It is so past time that we need a court to step up and do the hard work and look at this and say, this is not either constitutional at all, or if they decide it is, they say, this is not what really, truly this was meant to be.
I think it.
That was mic drop, but since you guys have video, and I just broke my phone. I'm sorry. No, finish, please.
I was going to say, the level to which you just got fired up indicates to me.
Chris goes, it's another day. Wait till after the 3 martini lunch. I don't drink martinis, by the way.
This episode may have concluded, but it sets the table for the next episode to perhaps be Ven goes off on the whole damn system's out of order rant about these are the most egregious examples of government immunity that I can think of. You're not going to believe it, folks. Stay tuned.
That's interesting. Okay, Josh, job security. One more episode. That's it, though. Chris, what do you got, buddy?
Oh, I've got nothing else. I mean, yeah, Jason, I think you're totally correct, though. This is, you see the passion. It's hard to not be passionate about these issues when you work with these families and you have to be the one to break this news to them over and over and over. Here's
how we're closing out episode 30. So Ven Johnson Law started on May 13, 2014, when there may have been a slight disagreement between one Vernon R. Johnson and Jeffrey Feiger. So I walk up, and I am literally, I just snot all over my, sorry. I am the next week realizing that, of course, I had no plan, and I didn't plan on starting Ven Johnson Law, and I didn't have an office. So in my former home in Birmingham, I had a thing called a loft. That was the law office of Ven Johnson for a minute. And so my paralegal, Shannon, who they fired apparently right after I left, because I didn't plan on leaving, so I didn't say, you have to leave with me.
Jerry Maguire style.
Right, exactly. Yeah. And the fish, right, and the fish. But anyway, so we're talking, we're kind of laughing like, okay, now what do we do, right? I get a phone call from some hotshot lawyer, Chris Desmond, who works for the Michigan Court of Appeals.
I know him.
Yep. So he calls me up and says, well, Judge Stevens, who was a great trial judge in Wayne County, and then was a great judge in the Michigan Court of Appeals. Judge Stevens said that you just left and I should call you. It's like, bro, tell Judge Stevens, not only do I not have an appeal, I don't even have a fucking file yet. Okay. But so Chris, did you come in like a month late? We at least talked
I interviewed with you
face.
in June of that year.
And what did we talk about that day?
The very first conversation was governmental immunity.
And
I came in and Ven started asking me what I wanted to do, and I was explaining to him I hate the way the law operates, and I see this, and I want to, instead of be working behind the scenes in the court, I want to be an advocate, and I want to work on these issues, try to fight against them. And we've literally, 14 years now. We've been
over 14, right?
Yeah.
And so we talked about
14 years and 7 days, or 17 days to be exact.
And so we talked about Robinson versus City of Detroit. We talked about the Dady's decision that was approximate cause versus the approximate cause. We talked about all this stuff. And the thing that I want everyone to get on the way out here is this. This is not just me. This is not just plaintiff lawyers. Overwhelmingly, if you had a civil defense attorney who you would talk with at a bar, at a restaurant, whatever, and having a real conversation like, all right, dude, don't tell me. I know that it helps you if you're defending a governmental entity and that's where you can win and not have to pay, Johnson firm millions of dollars. Okay, but straight up fairness. They would tell you the same freaking things that Chris and I are telling you. And is it fair? No, it's not fair to my other clients who don't have all these special privileges. So it's not like it's just this thing and this is where I go, well, don't you make money doing that? Yeah, I make, so do doctors, so do fire people. I mean, anyway, we all make money, but does that mean that I am pimping out the system? And quite the opposite. My number one goal is to make the law fair for every single person, no matter what you look like, where you come from, how rich or poor, skin color, religion, no religion, how you identify. I don't give a shit. You deserve the same amount of rights that I do, that you do, and anybody else does. And until we get there, I guess we're going to have a lot more podcasts to do.
I hope so.
All right. Appreciate y'all. Episode 30 signing out. Stay tuned. More Gloves Off podcasts to come. So my marketing people tell me, right? Holly and Josh, NPR, Chelsea. Love you guys. Bye.